All of you are familiar with workplace investigations. You may have conducted them yourselves, or you may have brought in investigators or counsel to conduct them for you. As you know, workplace investigations are critical in response to allegations of unlawful discrimination or harassment in your workplace. Should there be such complaints, should there be such allegations, the employer is required to investigate, to address, and to remedy the problem. Complaints, however, cannot be kept confidential. So if a complainant comes to you and says, here are my issues, here are my concerns, please don't tell anybody, what do we tell them? We tell them, I will keep this confidential to the fullest extent possible. However, we have an obligation to investigate what you have brought to our attention. That's a very important piece. I know sometimes it's difficult because people come to HR, they want to confide, and of course you want them to trust you and to be open, but we must be honest that we cannot keep this information confidential because although we will respect their privacy to the fullest extent possible, we must investigate. Now, one of the common practices in workplace investigations is to instruct complainants and instruct witnesses that they must keep all of the conversation in their interview within the scope of the investigation completely confidential. And I know, talking to my clients and being out in the field, that this is still a common practice for investigators and for HR folks to tell everyone they talk to during the scope of the investigation to keep the conversation confidential. This is not legal. And the reason is because, as Gary mentioned earlier, under the National Labor Relations Act, employees have a right to concerted activity, protected concerted activity under Section 7 of the National Labor Relations Act, which means that protected concerted activity occurs when employees take action or engage in any communication for their mutual aid or protection regarding terms and conditions of employment. And it has been held that this includes the employee's rights to discuss disciplinary investigations with fellow employees. Hence, under the NLRA, employees have a legal right to talk about what's going on in the investigation, what's going on with respect to issues in the workplace, terms and conditions of employment, and potential discipline that may arise from the investigation. So how do we deal with this? The way we deal with this is that we keep in mind that blanket confidentiality is not lawful, and instead we need to do a certain amount of legwork up front before we start the investigation to determine whether a confidentiality instruction is appropriate and lawful. And a case called Banner Health System has spelled out for us exactly what we need to do in order to make the initial finding that a confidentiality instruction is appropriate as we go through the investigation. What I recommend for my clients and what I do when I'm brought in to investigate workplace allegations is that we document this initial threshold analysis in a memo that goes into the investigation file. Here's the way it works. Before instructing the claimant or any witnesses to keep workplace investigation confidential, you must, or your investigator must, conduct a case-specific analysis to find that non-disclosure is necessary because of one of these reasons. Confidentiality is necessary because there is a need to protect a witness or witnesses, because there is a likelihood that evidence will be destroyed, because there is a threat that testimony from witnesses could be fabricated, or there is a need to prevent some kind of a cover-up. In my experience, you're going to find one or more of these grounds for a confidentiality instruction in almost every situation. But it is a requirement that you do this analysis, and I recommend as a best practice that you document the analysis, document your findings, again, before the investigation occurs, before you give anyone a confidentiality instruction, any of your witnesses or the claimant. And then as you go through the investigation, I've done some workplace investigations that involve over 100 witnesses. So as you're going through the investigation, circumstances change, you become aware of new facts, and a reanalysis or revisiting of this analysis periodically throughout the investigation is appropriate and helpful and should be documented, so that if new facts come to light, you can take that into consideration in your analysis of your confidentiality instruction. There's a lot more that we can discuss with respect to workplace investigations. It's a complex area, and I caution you to be sure that you have all your ducks in a row, that you've talked to your counsel, that when appropriate you've brought in a neutral fact finder to conduct your investigations, so that your investigation is done properly, is documented properly, and will withstand scrutiny should there be a legal claim.